Hello, I'm Shirley Whitenack. I'm a partner with Skank Price Smith & King with offices in Florham Park and Paramus, New Jersey. Many elder law attorneys practice in the area of Social Security hearings and appeals, and we're going to be spending the next few minutes discussing the basics of this practice. There are 5 stages of claim review: the initial determination, reconsideration, hearing, appeals counsel review, and judicial review. We're going to talk about the hearing, appeals counsel review, and judicial review in this segment. So let's start with the hearing process. The hearing process starts after application for benefits has been denied at the initial and reconsideration level. The hearing is held before an administrative law judge, also known as an ALJ. A written request for a hearing should be made within 60 days after receipt of the decision. Prior to the hearing, there are several things that an attorney will want to do. Incidentally, if you are an attorney who is going to be assisting your client in a Social Security hearing, it is important for your client to notify Social Security in writing that they have engaged an attorney to represent them. So what you'll want to do is review the evidence in the case file, and you will also want to submit any new evidence that may be relevant to your client's case. When you're at the hearing, it's important, if possible, to bring your client with you. The client should attend the hearing, even if you are representing them, because it gives the ALJ, the judge in the case, a sense of what the person physically and mentally is like, and can be important to the considerations that the judge is taking into account. The hearing is often conducted in person, but it can also be conducted via video teleconference. The hearing is informal, but it is recorded, and the rules of evidence don't apply. At the hearing, the administrative law judge will explain the issues and introduce the case. The judge will deal with admission of exhibits and objections to those exhibits if there are any from any party. Then the claimant's attorney will make an opening statement, and the witnesses will be sworn in to testify. And the testimony will begin by the claimant and any other witnesses that have been brought to the hearing. Now, when the testimony begins, the judge may ask questions to begin the process, or the judge may direct the claimant's attorney to start the process of testimony. In this regard, it's important to understand what kind of evidence should be submitted at the hearing. And the testimony of the claimant and the other witnesses should concern the things that the claimant can and can't do with respect to his or her job. In other words, you want to ask the claimant questions about not the diagnosis, because the diagnosis is going to be in the claim file, but about the claimant's past work history and what kind of tasks they performed during that work period, because the ALJ is going to have to determine whether your client can or cannot perform any of those jobs that were previously held. And the questioning should also focus, if there is a physical disability, on things that the claimant can or can't do. For example, lift things, bend down to tie a shoe, range of mobility. If it is a psychiatric condition, you will want to focus your questions on questions dealing with the mental status of the claimant. At the end of the testimony, the other side or the ALJ will have the right to cross-examination of witnesses. If there are witnesses on the other side, you, as the claimant's representative, will have the right to cross-examine those witnesses as well. Then you'll make your closing argument, and the administrative law judge will deal with any optional requests that anybody may have with regard to the evidence that has been presented. Then you will make your, after you make your requests, the ALJ will make its closing statement. After the hearing, the administrative law judge will issue a written decision containing the findings of fact and the reasons for the decision. The decision must be based on evidence at the hearing or included in the record. And a fee petition should be submitted if the claimant prevails. In this regard, you should know, as the claimant's attorney, that you cannot charge your client unless you first notify the Social Security Administration and fill out certain forms so that you can be paid from the claimant's money. The only time that this is not necessary will be if a third party is actually going to pay your fees. So if you are being paid, for example, by a business or another firm or a nonprofit agency, then you don't have to go through this procedure, but otherwise you must notify the Social Security Administration and fill out forms, which you can get on the Social Security Administration website at ssa.gov, before you charge a fee. Now, if the hearing results in an adverse determination for your client, the next step is a review from the Appeals Council. A written request for review by the Appeals Council should be made within 60 days after receipt of the hearing decision. But be very careful if you decide to appeal to the Appeals Council, because the Appeals Council may overturn an administrative law judge's decision even if it was supported by substantial evidence. So if there are areas of the administrative law judge's decision that you liked and certain areas that you did not like, the Appeals Council can overturn the entire decision. The Appeals Council is comprised of 3 members, and the review by the Appeals Council is limited to determining whether there was abuse of discretion by the administrative law judge, errors of law, findings or conclusions that are unsupported by the evidence, issues affecting the public interest, or new material evidence that was submitted with a request for the review. The review is based on the record, the brief, if any, and any new evidence relating to the period on or before the date of the administrative law judge's decision. Oral argument may be permitted if the case raises important questions of law or policy, but generally no oral argument is heard. The Appeals Council has several options for dealing with its determination. It can affirm the decision of the administrative law judge, it could reverse the decision, it could modify the decision, or it could remand the case back to the administrative law judge with certain instructions. Sometimes determinations are reopened, and we'll spend a few minutes talking about that. The time for reopening a decision can occur within 1 year of the initial determination for any reason, and within 4 years of the initial determination if the Appeals Council finds good cause to do so. A case can also be reopened at any time for reasons such as fraud or duplicated related claims based on the same earnings record, or within specified times for special cases. If you are unsuccessful with the Appeals Review Council, you can then get a judicial review. If you are seeking a judicial review, you are going to have to make a written request for review by a federal district court within 60 days after the decision is mailed. And you file this request for review with the federal district court where the claimant resides. The scope of review is going to be limited to whether the appeals counsel's decision is supported by substantial evidence and whether proper legal standards were applied. In the judicial review, the claimant will file a complaint, and the commissioner will file an answer and a certified copy of the transcript of record. There then will be discovery of documents, and a motion for summary judgment can be made and considered. The judge will then enter judgment which will affirm, reverse, modify, or remand the decision. And if your claimant is not successful, you have a right to appeal to the Federal Circuit Court.